is a matter of State of Ohio versus L.C. Dodson Jr. We're back on the record. Case number B2301832. Mr. Dodson is present in the courtroom. This matter is set for jury trial today, but it's my understanding the parties have reached an agreement regarding resolving the matter by way of a plea, open plea, and not having a trial. Is that accurate, counsel?
Yes, that is correct.
Is that how you want to proceed today, Mr. Dodson?
Yes, ma'am.
All right, Ms. Caitlin Brewer is present for the State of Ohio. Are you the L.C. Dodson Jr. named in this indictment?
Yes, ma'am.
Mr. Dodson, how old are you?
33
How far did you go in school?
to 11.
All right, did you ever graduate?
No, ma'am.
Did you ever obtain your GED?
No, ma'am.
Do you have a desire to do that?
Yes, ma'am.
All right. Are you able to read and write the English language well?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am.
Mr. Dodson, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Ms. Ragland's signature here. Sir, is this your signature, or did you start to sign and stop?
That's my second.
That's how you sign? That's very unique, okay? This is an acknowledgement by you that you understand you have a constitutional right to have a trial, which is set for today. But when you sign this form, you're indicating to the court, I understand that, but I don't want a trial. I'm waiving or giving up my right to have a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after you consulted with Ms. Ragland about your right to have a trial?
Yes, ma'am.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to have a trial?
No, ma'am.
I also have in my hand, Mr. Dodson, a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page of this document, there are signatures. I recognize the prosecutor's signature here, Ms. Ragland's signature here, and then up here, is this your unique signature?
Yes, ma'am.
All right. Madam Prosecutor, would you put on the record what the party's expectation regarding the plea is?
Your Honor, he is going to issue an open plea in both charges to Your Honor. He's going to forfeit the firearm. Your Honor, you're going to set this out for a PSI and a victim, PSI, not victim impact, sorry. Set this out for a pre-sentence investigation, and then Mr. Dodson is going to talk to you about sentencing.
All right, thank you. Is that accurate, Ms. Ragland?
Yes, that is correct.
Okay. Is that your understanding too, Mr. Dodson?
Yes, ma'am.
All right. Sir, are you under the influence of any medications, alcohol, or drugs today?
No, ma'am.
Do you now, or have you ever had to manage any type of mental health difficulties?
No, ma'am.
All right, so have you ever been diagnosed with any type of mental health difficulties? And that could be ADHD, which is, attention issues.
Consider bipolar.
Okay, all right, so you've been diagnosed with bipolar.
Yes, ma'am.
Have you ever been prescribed any medication?
Yes, ma'am.
Are you currently still taking the medication?
No, ma'am.
When did you stop?
Been 2 years.
A few years. And did a doctor terminate your medication regimen, or did you just stop?
I just stopped taking
Okay. Have you been under doctor's care in the last couple of years?
it. No, ma'am.
All right. So I know there have been a little bit of confusion about the understanding of the plea. Let me ask you this. Have you had good communications with Ms. Ragland about your case?
Yes, ma'am.
All right. Have you been able to understand all that she has advised you?
Yes, ma'am.
All right. Have you been able to fully communicate to her what your thoughts are and what your wishes are?
Yes, ma'am.
All right. Ms. Ragland, put on the record whether or not you believe that Mr. Dodson appreciates the nature of the charges and has effectively been able to communicate with you regarding his defense?
I do believe so.
All right. Mr. Dodson, are you presently under any type of probation or community control supervision in this state or any other state?
Yes, ma'am.
Can you tell me about that?
PRC.
All right, I didn't know you were PRC. But what about probation?
No, ma'am.
Okay. Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything if you enter into this guilty plea today?
No, ma'am.
Are you making this plea of your own free will?
Yes, ma'am.
Now, the state has indicated that it's expected that you would enter a guilty plea to both counts of the indictment. Count 1 being carrying a concealed weapon, felony of the 4th degree, and count 2 being having weapons while under disability, a felony of the 3rd degree. Is that what you talked with Ms. Ragland about before this hearing?
Yes, ma'am.
And as I previously discussed with you, for purposes of sentencing, those 2 counts merge into one sentence. Do you understand?
Yes, ma'am.
All right. Did you have an opportunity, Mr. Dodson, to go over this 3-page plea form with Ms. Ragland before this hearing today?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
Do you have any questions about it?
No, ma'am.
Did Ms. Ragland answer all of your questions about it?
Yes, ma'am.
Mr. Dodson, do you believe you've had enough time to sufficiently consult with your attorney about your entire case before this hearing today?
Yes, ma'am.
And has Ms. Ragland answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to either review or discuss with Ms. Ragland the evidence, the discovery that the state has against you?
Yes, ma'am.
Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge, to this defense?
Your, to my knowledge, all matters have been provided.
All right, Ms. Ragland, you acknowledge to the same?
Yes, I do.
All right, Mr. Dodson, are you satisfied with your lawyer, Ms. Ragland?
Yes, ma'am.
Now, do you understand these 2 charges against you? Carrying a concealed weapon, a felony of the 4th degree, and having weapons while under disability, a felony of the 3rd degree?
Yes, ma'am.
Do you understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in the indictment?
Yes, ma'am.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and just proceed to sentence you immediately?
Yes, ma'am.
Now, I think you know already that I'm going to be getting a pre-sentence investigation report, so I will not be sentencing you immediately, but I could. Do you understand?
Yes, ma'am.
All right. Now, count 1, carrying a concealed weapon, being a felony of the 4th degree, do you understand you're facing up to 18 months in prison, up to a maximum fine of $5,000?
Yes, ma'am.
And on count 2, having weapons while under disability, do you understand that you are facing up to 36 months in prison and up to a $10,000 maximum fine?
Yes, ma'am.
You understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years.
Yes, ma'am.
All right. Ms. Ragland, you filled this out accurately, but would you mind adding in the PRC column up to 2 years? Just under the words may. I'm just having her add what I just advised you, okay? And that is, upon your release from prison, you could be, which is may, be on post-release control for up to 2 years. You understand?
Yes.
All right. Do you want to share with me to make sure that he sees that? Did you see that, Mr. Johnson?
Yes, ma'am.
All right. And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. You understand that?
Yes, ma'am.
Now, you are on PRC right now, post-release control, correct? All right. Do you understand that if you are convicted of a new felony offense while on post-release control, that in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. That's a possibility. Do you understand?
Yes, ma'am.
All right. Since these are felonies of the third and fourth degree, community control or probation is a possibility. Do you understand that I could place you on probation for up to 5 years instead of sending you to prison?
Yes, ma'am.
Do you understand that if I place you on community control, you would have to abide by all probationary conditions as established by this court?
Yes, ma'am.
And do you understand that if I place you on community control and you violate the conditions of community control, you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time up to 18 months on count 1 and up to 36 months on count 2. Do you understand?
Yes, ma'am.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand that?
Yes, ma'am.
You have any questions so far?
No, ma'am.
Mr. Dodson, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, ma'am.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you?
Yes, ma'am.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes, ma'am.
Do you understand each of these rights as I've explained them?
Yes, ma'am.
Do you have any questions whatsoever about your constitutional rights?
No, ma'am.
Do you have any questions whatsoever about anything we've discussed today?
No, ma'am.
Do you understand that if you plead guilty to these offenses, you are giving up or waiving all of your important constitutional rights?
Yes, ma'am.
Knowing everything the court has discussed with you today, Mr. Dodson, do you still wish to enter a guilty plea as charged to counts 1 and 2 of the indictment, carrying a concealed weapon and having weapons while on disability?
Yes, ma'am.
All right. Counsel, is there anything further before I accept the plea?
That's correct.
All right. May I hear a statement of facts, please?
Elsie Dotson, on or about the 24th day of April 2023, Hamilton County, State of Ohio, knowingly carried or had concealed on his person or concealed ready to the hand a handgun other than a dangerous ordinance. The weapon involved is a firearm, either loaded or ammunition ready at the hand in violation of section 2923.1282 of the Ohio Revised Code. Then, Your Honor, same date of offense, Elsie Dotson, on or about that same date, Hamilton County, State of Ohio, knowingly acquired, had, carried, or used a firearm or dangerous ordinance to it, a firearm at the time of the defendant had been convicted of a felony offense violent to it, had been convicted of a drug possession case to it, aggravated possession of drugs, Hamilton County Court of Common Pleas under case number B22-04192 from November the 30th of 2022, and from that point, the defendant had not been relieved from such disability under operation of the law or legal process in violation of 2923.1382 of the Ohio Revised Code. As the court has specified that Elsie Dotson on April the 24th, 2023 possessed a high standard 22 caliber firearm and said property was used to commission both counts.
All right, thank you. Anything on those facts?
Nothing on the back.
Mr. Dotson, you hear what the prosecutor said that you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
What is your plea to count 1, carrying a concealed weapon, a felony of the 4th degree?
Guilty.
What is your plea to count 2, having weapons while on disability, a felony of the 3rd degree?
Guilty.
Let the record reflect that Mr. L.C. Dotson Jr. was present in court with his attorney, Ms. Ryan Wagner, and that Mr. Dotson was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. L.C. Dotson understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding them to be voluntary, the court accepts the guilty pleas and finds L.C. Dotson Jr. guilty as to count 1, carrying a concealed weapon, felony of the fourth degree, in violation of revised code 2923.12 subsection A2, and guilty as to count 2, having weapons while under disability, felony of the third degree, in violation of revised code 2923.13 subsection A2. Is there any reason why a sentence should not be entered? Get the PSI? All right, get the PSI. All right, Ms. Howard, give me the date. August 21st.
I can do the 22nd.
Can you do the 23rd?
Yes, I can do something.
August 23rd at 9 a.m. All right, Mr. Johnson, your sentencing will be on August 23rd. I'll get a pre-sentence investigation report. So somebody from probation will come and talk to you, and then they'll write a report. And I'll get a chance to review that report, learn a little bit more about you, and then I will share it with your attorney and the prosecutor. And then on 23rd of August, we will come back at 9 a.m. and then we'll go over sentencing. And I'll hear from you at that time, and Ms. Ragland, and the state. Okay? Do you have any questions?
No, ma'am.
All right, I'll see you then. Finish your minute.
Sidebar.
Objection. I'm just gonna have this. The effective for you to do it. Okay.
Judge, I think we'll get this done. And if she has an objection, put over tomorrow. If that would be possible. It's highly likely that
Right.
I know you said you reduced it. There may be some issue with jail time credit and so forth. With your honor, would you likely do it in 6 months concurrent with what he's got?
Yeah.
So I think if you got that 4 months.
Yeah.
6 months looks like 6 months.
Yes.
Okay. And I think that also there was some body cam that I missed. So I didn't have time to. Okay. I just want to make sure I've gone over what the.
No. Ms. Howard, can we set, minutes over for Wednesday, please?
This Wednesday?
Yes. All right, the Thursday for a plea?
Yes, Your Honor.
All right, you need me to bring him down?
No, I'll be talking to him.
All right, I'm gonna, set this for a plea on Thursday, 20th at 9.
All right.
Thank you.
Thanks for your patience, Your Honor.
All right, thank you. Any wait time to this?
Wait, time.
Yes, let's do that, okay. This is the matter of State of Ohio versus Trayvon Edwards, case number B 2301215. Mr. Brian Perkins, present for Mr. Edwards, Ms. Rue for the State of Ohio. This matter is being continued at the request of the parties as plea negotiations are in place. And council would like a little bit more time to review some videotape.
That's correct, Your Honor.
All right, so we'll set this over to July 20th, which is a few days from now, 3 days from now, Thursday, July 20th at 9 a.m. Is that going to be complete, Mr. Perkins?
That will be complete, Your Honor.
And time waived till then?
Timeless waive, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. And Your Honor, I believe that concludes my portion of the docket.
Oh,
I will see you Wednesday.
see you Wednesday. Thank you. With
Mr. Hedge?
were you, told you last night to?
I was ready just to stand in, and I realized I did my regular stuff, I went back to the desk, and I realized this stuff, I was still sitting there. So I came back over as soon as I saw it.
Oh, gotcha, okay, well, I agree.
Yeah, we were gonna be asking, that he's got another thing holding him, so we were just gonna. We can, so we can do that.
Yeah, because he just said that it's nobody's here. Okay, we get the date,
No, I don't know.
Wednesday. That's next week.
Next Wednesday, okay.
Okay, thank you. All right, then that will complete the information set. Just, unless you want to be aside.
We just want to. Yeah, that's good.
You want to be aside? Yeah, I want to see.
Before we start, can I just review the document on our presence for those on the end this morning? Thank you.
We need to set some date on how to gate. PSI to.
So we have to read some.
Yeah, you know what, I think you guys,
Is it just ABPLEGA?
yeah, you gotta shoot before.
Okay,
We
that's
realized on Friday, they should.
Thank you. Okay.
Charles not ready to do it.
Thank you. Yeah, I was looking.
Right.
I think we're just changing one change
Okay, good.
Is it, should be available on the 21st,
I'm
August 21st?
for the week of the 28th. That's possibly the trial.
Are you out that week?
I'm not out that week, I have a trial that's going to start on Monday.
Starts on the 21st.
Yes,
All right, what date do we know?
Maybe 28th.
Okay, August 28th.
Yes,
I'm sorry, did you say?
August 28th, is that good?
That would be fine.
All right. Christine, do we have any, status on the entry?
I got Humana's signature, I'm just waiting for the switch on yet. On this morning after 4. I'm like,
What's the holdup?
So I wasn't aware of what statute shows, but between two subsections, which I'm not sure what the defendants have said.
Is it, same reduction?
Yes.
Oh,
Same
okay,
thing.
everything's the same, okay.
Just wouldn't be able to.
Okay.
there's a lot of things like the process for that. I was looking to speak to attorney, Sean, please. Is Josh Kennedy in? He's the other attorney. eventually. I'm just leaving that. Enforcement edit to that. You know, I appreciate it. I'm gonna call back.
Alright, so you just have Dodson, seven, yeah, because it's, okay, so I was just trying to be multitask. So, can you push on it and see if it goes through? Yes. Okay.
This is Lauren from Judge Process. I left a message from Mr. Kenny. Would I could speak to Mr. Chinese, Elder Chinese, paralegal or law firm. This is the state of Lynn, I tried last week. All right, thank you.
This is the matter of State of Ohio versus Charles Applegate Jr., case number B2205798. Mr. Applegate is present in the courtroom with his attorney, Ms. Amy Dedish, and Mr. Nick Rampick in the State of Ohio. This matter is on for jury trial today, but it's my understanding the parties have reached an agreement, and I've been handed plea documents. Is this how your client wishes to proceed today, Ms. Dedish?
It is, Your
Mr. Applegate, is that accurate? All right. Checking something. So you're Charles Applegate Jr. Can you do me a favor and put Junior on these documents here, because that's important. As well as the felony sentencing bond. All right. Are you the Charles Applegate Jr. named in this indictment? Mr. Applegate, how old are you? All right, can you step to the mic so I can hear you better? Thank you. You're 24 years old? All right, just go closer to you. Thank you. How far did you go to school?
High school.
Did you graduate? All right, how far did you go in? 10th grade, all right. Did you ever obtain your GED? All right, is that something you want to do? All right. Are you able to read and write English language well? Are you a U.S. citizen? Have you ever served in the military? All right. Mr. Applegate, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize your attorney, Ms. Dedish's signature here, but right here, this looks like initials. Is this your signature? Is this how you sign your name, or you just put your initials here? You sign like this? Okay. This is an acknowledgement by you that you understand that you have a constitutional right to have a trial. But when you sign this form, you're indicating, I understand that, but I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form? Did you sign this form after consulting with Ms. Dedish about your constitutional right to a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? I also have in my hand a 3-page document entitled Entry, Withdrawing, Plea of Not Guilty, and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize Mr. Grant's signature here. No, that's Ms. Bruce's signature for Mr. Grant. Right?
Correct, yes.
And then Ms. Dedish's signature here, and then up here, is this your signature, sir? Can you see it from there? You can step up a little bit. Is this your signature here?
Yes.
All right, thank you very much. Mr. Prosecutor, would you please put on the record the party's expectation regarding the plea?
Yes, Judge, this is a single count indictment. Count 1 is gross sexual imposition, 2907.05A4, felony with 3rd degree. The state would move to amend that to 2907.05A1, felony with 4th degree, 05A1, in exchange for guilty plea, Judge.
Is that accurate, Ms. Dedish?
It is true.
All right, is that your understanding too, Mr. Applegate? All right. So are you under the influence of any medications, alcohol, or drugs today? Do you now, or have you ever had to manage any type of mental health difficulties? All right. Are you presently under any type of probation or community control supervision in this state or any other state? Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this guilty plea today? All right. Are you making this plea of your own free will?
Yes.
Now, the state has indicated that in exchange for your guilty plea to count 1, the state is asking the court to reduce the charge from gross sexual imposition, a felony of the 3rd degree, down to a felony of the 4th degree. Is that what you talked with Ms. Dedish about before this hearing today?
Yes.
And did you have an opportunity to read and or review with your attorney this 3-page plea form?
Yes.
Do you understand what it says?
Yes.
Do you have any questions about it? Did Ms. Dedish answer all of your questions about it? Mr. Applegate, do you believe that you've had sufficient time to fully consult with Ms. Dedish about your entire case before this hearing today? And has Ms. Dedish answered all of your questions to your satisfaction? Have you had an opportunity to review and or discuss the discovery evidence that the state has against you with Ms. Dedish? All right. Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge?
To my knowledge, everything was provided.
All right, Ms. Dedish, you acknowledge what you're saying?
Thank you, Your Honor.
All right. Mr. Applegate, are you satisfied with your attorney, Ms. Dedish?
Yes.
Now, do you understand this charge against you, gross sexual imposition, a felony of the 4th degree? Do you understand that charge?
Yes.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in that reduced charge in the indictment? Do you understand? Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes.
Now, this being reduced to a felony of the 4th degree, do you understand that you're facing up to 18 months in prison, up to a maximum fine of $5,000?
Yes.
Do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that?
Yes.
Are you on post-release control right now? Well, do you understand that if you are on post-release control and you commit a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand? Do you have any questions? Since this is a felony of the 4th degree, community control or probation is a possibility. Do you understand that I could place you on community control for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions of community control, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time up to the 18 months that I previously discussed with you. Do you understand? Do you have any questions? Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand that? Mr. Applegate, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Do you understand that? Do you understand all of these rights as I've explained them? Do you have any questions whatsoever about your constitutional rights? Do you have any questions whatsoever about anything we've discussed today? Do you understand that if you plead guilty, you are waiving all of these important constitutional rights? Yes. Knowing everything the court has discussed with you today, do you still wish to enter a guilty plea to the reduced charge of gross sexual imposition, a felony of the 4th degree? All right, counsel, is there anything further before I accept the plea?
No.
All right, can you hear the statement of facts?
Yes, Judge. Charles Applegate Jr. from on or about the 1st of July 2022 to on or about July 20th, 2022, Hamilton County, State of Ohio, purposely had sexual contact with BC, a person who was not Charles Applegate Jr.'s spouse at the time. And as it's amended, the defendant purposely compelled victim BC or one of the other persons to submit by force or threat of force. Your Honor, it was originally charged under the A4 statute, as the victim was 9 years old and under that 13-year-old threshold. The story on this is the victim BC lives up in Michigan. I'm not positive on custody, but she is not living with her mother at the time. But she traveled to Cincinnati to visit her mother. The mother is sisters with the defendant here, so the uncle to this victim, the 9-year-old victim. While on the couch at home, the defendant touched the victim in her general area, in her vaginal area, underneath her hands, but over top her underwear. He was rubbing that area for some time. The defendant, or the victim at that time, told authorities, and that's how the investigation started.
All right, thank you very much. Mr. Applegate, here, the prosecutor said you did?
Yes.
Is it true?
Yes.
What is your plea to count 1, gross sexual imposition, a felony of the 4th degree?
Guilty.
Let the record reflect that Charles Applegate Jr. was present in court with his attorney, Ms. Amy Geddes, and that Mr. Applegate was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Applegate understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Charles Applegate Jr. guilty as to count 1, gross sexual imposition, reduced to a felony of the 4th degree in violation of revised code 2907.05, subsection A1. All right, is there any reason why sentence should not be entered today?
From the state, yes, Your Honor, the victims have been aware of this plea, they've been very active in communication with me. They were not here present, I did inform them that plea was going to take place, and they're asking for victim impact.
All right, I am going to order a victim impact, and as well, I think the PSI would be helpful. Ms. Dennis, do you agree?
Yes, sir.
All right, so I'll go ahead and order a PSI and a victim impact. We will continue this matter for sentencing on August 28th at 9 a.m. Mr. Applegate, you must go to the probation department immediately following court, right on the first floor. Ms. Dennis can either direct you or accompany you there. You must cooperate fully with their investigation and answer all questions truthfully. Now, it's only going to take a few minutes, probably 20 minutes at the most. And then you'll return to court for sentencing on August 28th at 9 a.m. Failure to do any one of those things, go downstairs and do the report, failure to answer truthfully, or failure to come back for sentencing, will be a violation of the court's order, and your bond will be revoked and forfeited. You understand? All right. Now, I will see you on August 28th. Do you have any questions? All right. There's nothing else from council. We'll adjourn, and I'll see you on 28th August. Thank you.
Thank you, Judge.
Do you have a docket tomorrow? Do we have tomorrow? Right. Yeah, just me.
Okay.
Also, you're so good.
So we're going to-
Yes. Yes. There's a lot of it, yes.
So that, we started trying to every single day, but what we did was we figured out a way to give it one writing day.
I love that. I love that your docket.
And then also I taught law school last semester, and I taught Monday nights. And I
I'm hard
really,
to come in Tuesday.
it made it, well, I would come in, but just to have court again that morning, it's just so very difficult. So we just use Tuesday as my writing day, and I did a lot of administrative stuff. So
Oh, I love
it's
that.
been really working, even though for the
Very
summer I'm not teaching. So that's,
Yeah, you're very efficient.
and all the prosecutors who come in here, who rotate in, I do stuff.
Oh,
Because it
absolutely.
gives them an opportunity to.
Well, they
get-
got, you see their case list, I mean, they're trying to prepare.
Yes. And then we also, because we do certain things on certain days, they also know that they don't have on Monday a child, emotional stress, compass, all these different things. They know that it's just this, and on Wednesdays it's bench trials, this day. And I just think that it's easier for everybody involved.
Well, I agree. It's trying to find that balance, work.
It is,
balance.
it is,
It's important.
yes, it's very valuable.
Yes. No, lately I don't have a very good work-life balance, but it's not because of the stock, it's just my caseload right now, but it's getting better. We'll be better at it.
Straight better.
Yes. It's just, I have this one woman who's so difficult to understand, and it just makes it so much longer for me to get my work out. They needed an interpreter. Sometimes I can understand.
All right, Julian, I think we might have some copies that Julian can make. Or, no.
those things.
Okay, I actually had those last, so I can make
He gave you the flash drive?
Yeah.
Okay, good.
either explain it too, so I can scan or copy or whatever.
Yeah, I'm gonna go get those things because it's a lot. So, give me this exact one.
And then you can take a bunch of one.
No. Yes, you got about an hour more than you do for the lunch, so let's get him up here so we can, get him started on, something.
You know, for my name.
Yeah.
Okay, so I called first, we said how to look at it, so I left a message and then I called back and spoke to the paralegal. Apparently she's out of state, but I forwarded her all the drafts, so she's gonna try to reach out to her. Or she believes Mr. Kenny will be back in on Wednesdays, apparently he's also out,
And what
the final entry. And according to Rule 58, we do need all our signatures before we can
do the final entry?
So she's gonna try to touch base and keep me updated, but I forwarded her the I'm missing just one council signature. You're sent back edits for.
Okay.
Yeah, so I learned all about it last week.
You too, thank you. Yes, I have an appeal due the 27th, to be honest. I haven't even- Which is, when I don't recognize the name on the screen, I don't have a lot, right? Because when you look at it, you're like, I don't even know who that person is.
Yeah.
So I'm hoping that my theory is correct. All right, bye everyone. I'll see you Wednesday morning. Enjoy.
Thank you.
Thank you.